So I'd like to welcome you all to this session. It's called The Limits of Legal Remedies for Antisemitism. We've got 4 excellent presentations for you this afternoon. The first person who's going to present is Christoph Fischer. Christoph is a PhD student at Trier University in Germany, and he specializes in criminal law and anti-Semitism and crimes against the state, and he's going to speak about criminal liability of Israel related anti-Semitism in Germany. So Christoph will be our first speaker, and he has 20 minutes. I'll introduce the other speakers as we go along. It's okay? Yeah, all right.
Thank you very much. I hope I'm close enough to the microphone so that you can hear me, or I just take that one. I'm glad to have the opportunity to speak here today, as I am an early career researcher. My nose is a little congested, so if I sound a bit off, that's not usual. Okay. As you know, contemporary anti-Semitism often doesn't show its face directly. Especially in Germany, due to its past, anti-Semitism comes in the more subtle way of so-called criticism of Israel. After October 7, protests erupted all over the country. People shouting Hamas slogans, calling for the destruction of Israel, and demanding a complete cut of support from the government. This called law enforcement into action. Although free speech is guaranteed, there are limitations, and in severe cases of public hatred, there may even be punishment. This is something we already discussed in the free speech panel this morning, so I hope you didn't all hear everything twice. But let me start. Criminal law is always the state's last resort. This also means that it must be sufficiently clear what kind of behavior is punishable and what can be said or done without consequences. There are several provisions laying out this so-called principle of certainty. Okay, that was my starting point. Okay. First of all, the German Constitution determines that, quote, an act may be punished only if it was defined by a law as a criminal offense before the act was committed. The European Human Rights Convention, an international treaty Germany adheres to, states, no one shall be held guilty of any criminal offense on account of any act or omission which did not constitute a criminal offense under national or international law at the time when it was committed. The German Criminal Code also resembles the latter. An act can only incur a penalty if criminal liability was established by law before the act was committed. So, what is one to make of this? If the state wants to penalize Israel-related anti-Semitism, it has to define what that means. Now, there is no actual offense called Israel-related anti-Semitism. However, does the microphone still work? Okay. However, some more general offenses might be thinkable, and statements protected under Article 5 of the German Constitution, which guarantees free speech, cannot be punished. So a definition is still needed. Some of the statements heard in the protests might fall under Section 86A of the German Criminal Code, use of symbols of terrorist organizations. For example, from the river to the sea, Palestine will be free, could be seen as a slogan of Hamas. We will talk about that in a second. Section 130 German Criminal Code deals with what could be described as public hate speech. This so-called incitement of masses could be fulfilled when the offender spreads hatred so severe that it could disturb public peace, and that is the actual wording. It might also be interesting if anti-Semitism is the motive for criminal offense. Let's imagine a violent assault on someone who is Jewish because the perpetrator holds them accountable for the actions of the Israeli government. Since 2021, it is possible to punish anti-Semitically motivated crimes more severely in Germany. This might also be the case here. It is important to emphasize that the principle of certainty has kind of a two-component consequence. It A, obligates the legislator to lay down provisions in a sufficiently clear way, and B, obligates courts to stay inside the limits of the actual wording in the text when applying definitions. So you see, there are several reasons why it is important to define what Israel-related anti-Semitism is. Having now established the fundamental legal framework, I now want to show you how the judiciary currently deals with relevant offenses. Let's just have a look at what I talked about earlier. The slogan, "From the river to the sea, Palestine will be free." There have been several court decisions on the matter, some of them in criminal trials, some of them are administrative, for example, relating to public protests. To summarize right away, there is no common stance in courts when it comes to Israel-related anti-Semitism. As time is limited, I can only feature some of the decisions. I therefore choose the most extensive ones in terms of the stated arguments. I know about the latest decision in Munich, but it has not been published yet, so I won't take this into account right now. The Regional Court Mannheim ruled that the slogan "From the river to the sea, Palestine will be free" is not illegal. In essence, they argued that no specific solution to the conflict was implied with the statement. It's just a mere allusion to the historic territory of Palestine. What the court means by that is unclear to me, as the decision neither conclusively says what historic territory means, nor is it made clear how the call to have a Palestine exactly there where Israel currently is can mean anything else than the eradication of Israel. The Higher Administrative Court Munich decided for a more differentiated approach. I don't necessarily want to say that they choose the easiest way around the problem, but nevertheless, the court did not commit to a specific definition. Instead, they ruled that context is key. In this particular case, according to the court, there was no clear association to Hamas or the October 7 massacre, so the protesters' calls were not to be seen as illegal. Regional Court Berlin, however, didn't make that distinction. It assumed that "from the river to the sea" is clearly associated with Hamas and therefore a slogan of a terrorist organization. This was, in conclusion, also the standpoint in a relatively new decision from Munich, but as I said, I didn't include it for reasons. I admit the aforementioned cases are to some extent different. They nevertheless show a completely different approach from court to court. This is a problem. Remember, the principle of legal certainty demands that everyone knows which kind of behavior they could be punished for. So, what could we do to avoid this patchwork jurisdiction? First of all, according to the German constitution, judges are free in their decisions. They only have to abide by the law. Even the rulings of higher courts are not legally binding, except the German Constitutional Court. However, most courts follow the case law of higher courts in practice. But those can only make judgments if the cases are brought forward to them, which they often aren't. The highest criminal court, Bundesgerichtshof, for example, never had to decide on the matter of Israel-related anti-Semitism. Why? Nobody appealed. Neither the convicted nor the prosecutors. Another solution could be updated legislation. This, in fact, doesn't seem to be so far away from me at the moment. In November 2024, the German parliament passed a resolution adopting the IRA definition for anti-Semitism. The resolution has been widely criticized in mainstream and progressive media. But after all, the resolution is not legally binding to the judiciary, as it is not a legislative act. The legislator, nonetheless, has the possibility to change existing laws to adhere to the principle of certainty if he wants to punish Israel-related anti-Semitism. In my opinion, it is precisely the legislator's responsibility to do so, as checks and balances demands the legislative branch to make legislation. The jurisprudence's scope is limited to applying the law, not establishing it. Which definition new legislation uses doesn't matter as long as it is somehow clear where criminal liability begins. Whether it is the IRA definition or even Sharansky's 3D test. I cannot analyze every possible definition here, which is not my point right now anyways. Everything would be an improvement to the current situation. To summarize my thesis, there are several possible offenses Israel-related anti-Semitism might fall under. 2. There currently is no universally used definition in jurisprudence. 3. Therefore, changes in current provisions would make it easier to sanction Israel-related anti-Semitism. I'm looking forward to discussing with you, and thank you very much.
Our next speakers to my left we're going to have two speakers co-presenting the next paper. We have
Colin Kagel.
he pronounces it better than I do.
Better than me, maybe.
Yeah, that's right. So Colin and Till Hendelmeyer, to my immediate left, are both research assistants at Bundesverban Rias Berlin, which is the Federal Association of Departments for Research and Information on Antisemitism. Colin's areas of expertise, this gentleman here, are anti-Semitism and the police, the history of psychoanalysis and critical theory. And Till's areas of expertise are Jewish perspectives on anti-Semitism and the legal system in Germany. And together they're going to present for 20 minutes.
Thank you very much. I think we've just worked. In 2017, the Independent Expert Group on Antisemitism of the German Bundestag, or UEA, spoke of a divergence of perspectives between Jewish citizens and mainstream society. According to the report, the non-Jewish majority perceives the extent and manifestations of antisemitism very differently from Jews. According to a 2022 study, 70% of non-Jewish Germans believe that antisemitism plays only a minor role in Germany. By contrast, according to the latest FRA study from 2023, 82% of Jews living in Germany consider antisemitism to be a serious problem. This divergence of perspective is also reflected in public debates, which often focus not on anti-Semitic content as such, but on so-called accusations of antisemitism. When antisemitism is pointed out, it is often a question whether it qualifies as such at all, and as a result, the focus often shifts and controversy arises not over the acts themselves, but over their criticism as anti-Semitic. From the perspective of Jews, however, this is not a matter of making accusations. Rather, it is about defending themselves against attacks, defending their own selves from physical harm, and defending their own safety or their own multiple Jewish identities. The UEA report concludes that much of the experience of antisemitism remains invisible to the non-Jewish majority. Our work shows that this also applies to the police and judiciary. For today's presentation, we are bringing together the results of two research projects we have conducted at RIAS. One focuses on victims' experiences of prosecution of anti-Semitism in the German legal system. Here we analyzed 102 interviews, mostly with representatives of Jewish organizations and communities. And the other focuses on the police's approach to recording anti-Semitic crimes. Here we conducted 12 interviews with police and academic experts on police recordings, as well as their impacts on those affected by anti-Semitism. We also looked closely at individual cases to gain a better understanding of the underlying logic and categorization practices. Today we want to share with you some of our combined findings. For structural reasons, such as the definition criteria that a political or anti-Semitic motivation or attitude of perpetrators must be proven, the situation is leading to a situation where offender-centered knowledge is extremely important in police data collection. Lived experience of Jewish victims, on the other hand, are of minor concern and do not affect understanding or classification practices. This is particularly significant as the recording police officers, often from small or rural police stations, are responsible for ensuring that the case is recorded, correctly indexed and forwarded to specialized authorities. Gaps in recordings stem thus in large part from insufficient awareness to and knowledge of anti-Semitism, as well as a lack of sensitivity to those affected by anti-Semitism. To illustrate the problem, I will briefly present two examples that can be regarded as paradigmatic for our research. Example 1. Many cases we analyzed are simultaneously reported to us at RIAS and the police. It is noticeable that there are many anti-Semitic cases which are officially reported to the police, but do not appear as anti-Semitic in the police statistics. This is what happened in an incident where swastikas and other Nazi symbols were smeared on a memorial stone to the victims of the Shoah. When we asked the responsible criminal investigation department why this case did not appear correctly, we were told in writing that the case was classified as politically and right-wing motivated, but as it was a memorial for all victims of National Socialism and not explicitly a Jewish memorial, it was not classified as anti-Semitic. A footnote pointed out that these were the so-called Stolpersteine or stumbling stones of the sisters Henriette Katz and Frieda Rosenberg. Both sisters were deported to Minsk in November 1941 and died there, as it was written, presumably in a mass murder. The fact that the two sisters were of course Jewish and that the crime was almost certainly a case stemming from anti-Semitic guilt deflection does not have to seem to have occurred to the officials. Consequently, the case was never understood as anti-Semitic and thus didn't make it into the statistics. Second example, within police practice, we often observe difficulties in distinguishing between crimes in which Israel is addressed in the broadest sense and actual Israel-related or anti-Zionist anti-Semitism. In an exemplary case, and merely a day after 7 October, the following statement was made online. Look at the features, and I quote here, look at the features of these Jews. They look like you. They escaped the crimes of Germany and the persecution of Europe. The land of the Arabs was stolen and given to them as a home to live in. Shit, Hamas is resistance, not terrorism. The statement was tagged as an endorsement or advocacy of crime, and because of its connection to Hamas was understood as a case of religious ideology. However, it was not classified as anti-Semitic, even though Jews were actually mentioned by name. Israel was equated with Nazi Germany, and the brutal murder of Israelis was justified as resistance.
I will look into the German experiences with law enforcement. Analyzing the interviews, two main problems concerning the legal system came up. Firstly, problems with recognizing anti-Semitic motives in court, as Christoph already pointed out. Secondly, a lack of sensitivity to victims. Let's look into recognizing anti-Semitic motives in court. Only a few of the direct experiences with the legal system dealing with anti-Semitic crimes. However, when members of the community have negative experiences with the justice system, these experiences spread throughout the community and impact not only those directly involved, but also an involved third party. Okay, sorry about that. Some of the interviewees describe cases where they were dissatisfied with how the anti-Semitic motive was dealt with in court. Others say that they heard from friends or members of their community or via the media that there were legal cases in which anti-Semitic motives was not properly recognized. Addressing the anti-Semitic motive in court is important because bias-motivated crimes have to be punished harder in German law compared to normal crimes, as Christoph already pointed out. I'll show you an example from a major German city demonstrating how these experiences continue to have a strong impact on both the person themselves and third parties, and even for, years later after the incident. The interviewee reported that on their way home from the synagogue, they were attacked, suffering life-threatening injuries, and were subjected to anti-Semitic insults. This case of extreme violence was only barely survived thanks to a surgery, but for the victim, not only the crime itself, but also the way the legal system handled it was deeply distressing. During the trial that followed, the victim stated that every effort was made to prosecute the crime without considering the possible anti-Semitic motive. According to the interviewee, there's a bit of a mess up there in the presentation, sorry about that. According to the interviewee, the trial actively focused only on the crime itself while ignoring the potential anti-Semitic motivation. The interviewee suspects that this mission of anti-Semitism may itself have been motivated by anti-Semitic bias. Later in the interview, the respondent described their direct experience with the legal system as even more distressing and longer lasting than the initial victimization itself, although he nearly died in the incident. Some of the interviewees referred to the case just outlined. One person who was not directly involved in the incident told us about the trial. They too noted that the anti-Semitic motive was not addressed in court. In recounting this, the person expressed their anger and outrage over what they perceived as a questionable court judgment. They also became increasingly emotional as they spoke, showing that even years after the incident, and despite not being directly involved, this experience with the legal system has a large impact on members of the community. Such direct and indirect experiences also lead to frustration and a loss of trust in the legal system, which can in turn negatively impact the willingness to report future incidents. Another point that was being made in the interviews is insensitive behavior by judges and prosecutors and police officers towards victims. One example here would be the first-hand experience of one of our interviewees. This interview partner was assaulted during a pro-Israeli demonstration and suffered a head injury from it. In the following trial, they wanted to testify anonymously out of concern for the safety of their mother, because she was has previously been victimized by an anti-Semitic incident, and he wanted his own mother. Instead of being met with understanding or sympathy, he was laughed at by the judge for trying to protect his identity. The further course of the trial shows that the interviewee had hoped for empathy from the court. After another 4-year trial, finally a judge conducted the hearing in the appeal proceedings, which the interviewee described as empathetic and great. Looking at this example, we can clearly see that it makes a big difference for victims with who they have to deal with. So how do these So how do these experiences affect victims? Many interview partners told us about losing trust in the German legal system. Many of them said they would not report future anti-Semitic incidents to the police. Others reported hearing from others that they would not file a report. This is not just concerning because Jewish people should be able to trust the legal system and the police, but it's a problem for the legal system itself. Most anti-Semitic offenses are reported to the police by the victim themselves. If the already low reporting rates for anti-Semitism sink further, the dark figures becomes even bigger. Public discourse on anti-Semitism relies heavily on police statistics. If the police document a smaller percentage of the overall anti-Semitic incidents, offenses, the disparity of perspectives will grow even further. And coming to the end, I'd like to highlight a few of our points. First, the problem of a big subjective factor influencing how anti-Semitic cases are dealt with. How victims are treated and how anti-Semitic motives are addressed is mostly dependent on individual police officers, prosecutors, judges. These individuals need good guidelines and definition, and this is not just a gesture of goodwill, but a legal right under German and EU. To understand contemporary anti-Semitism, working definitions like the IRA definition are crucial. This definition has officially been incorporated into police documentation in Germany in 2019. However, to date, its application has been largely symbolic, especially as the examples that make the definition applicable are not included in the official documents. So it's just a tiny bit of the core definition and no mention of the 11 examples, which basically makes it unuseful. Sorry to speak so plainly. Many of the police experts we spoke to were familiar with the definition, but had rarely used or worked with it. Police officers, but also judges, need manageable means of recognizing anti-Semitism. This definition can serve as a basis, although not legally binding, but it can serve as a basis, in particular through its guiding examples, to recognize anti-Semitism. But as I just said, it's rarely known to police officers, so there is a lot of room for improvement. Thank you.
So I'd like to introduce our third and final speaker, Matthew Bolton, Dr. Matthew Bolton. He's currently a postdoctoral research student at Queen Mary University School of Law under the supervision of Professor Eric Hines, who some of us had the pleasure of hearing this morning. And yeah, Matthew's expertise really is what he's going to present on, which is the limits of legal remedies for anti-Semitism. And the name of his talk, or the title, is How Does Anti-Discrimination Law Understand Jewish Affinity to Israel? Thank you.
It's like I'm going to start singing or something. So it feels like. I actually changed the title, as you can see. So the title now is Anti-Semitism in Israel and the Competing Logics of Anti-Discrimination Law. And I'm going to be focusing on the UK. So the UK legal system, I think some of it does apply across Europe. Some of it might be UK specific, but perhaps we can talk about some of the differences and similarities. So the thing that drew me to this subject about how does the law understand a Jewish person's affinity to Israel. If a Jewish non-Israeli person has a certain affinity to Israel, how does the law understand that relationship? What drew me to the legal aspect of this is that over the past 10, 20 years, questions around Israel-related anti-Semitism have been drawn onto legal terrain in the UK, and I think in other countries as well. So obviously there's the big definition debate. How do you define anti-Semitism in law or in like this quasi-legal kind of form? There's also been a rise in cases of libel and defamation cases, and also kind of accusations of discrimination and harassment based on a kind of affinity to Israel. And so I was interested in how the law understands this, because when you start looking into it, when you move a political debate around Israel and anti-Semitism, a political or intellectual scholarly debate onto the terrain of law, it's not like there's a seamless transfer where you have the same ideas and concepts and you just put them in the courtroom and everything stays the same. To appear within the legal system, you kind of have to conform to the language of the law itself. And the language of the law is not the same as the language of the political and the scholarly debate. Something happens to those ideas when they enter the courtroom, and because of that difference between the political and the academic language and the legal debate, I think sometimes some of the confusion about some of the decisions that have been made in UK cases around anti-Semitism in Israel are to do with this kind of failure to really recognize the distinction between the different ways that the law thinks about these issues and the way that politics thinks about them. So the first big difference is that in UK law, the concept of anti-Semitism doesn't actually exist at all. There is no law banning anti-Semitism. It just doesn't exist in law. In the way, so you might have the definition debate, which has, okay, we're going to define the concept of anti-Semitism and we're going to say, this is what anti-Semitism is, and then this kind of behavior is anti-Semitic or this kind of behavior isn't anti-Semitic. That isn't how the law works at all. It doesn't start from this predetermined concept. What it does instead is it's based on this. I'm going to be focusing on anti-discrimination law, so it's kind of civil law, but it's also kind of true of hate crime, like criminal law as well. It's based on this protected characteristics model, which I think is, in European law as well, where the law kind of identifies a set of different characteristics which provide the grounds for individual claims of harassment or victimization. So the ones in the UK are age, race, religion, sex, disability, sexual orientation, pregnancy, and so on and so on. And so you have to show that a particular act of harassment or victimization was on the grounds of one of these protected characteristics, in order for the law to pick up on this. So in terms of anti-Semitism, the law does not identify Jewish people as a specific group who require kind of enhanced legal protection. That's not how it works. In order to get enhanced legal protection through this protected characteristics model, Jews essentially have to show how kind of Jewishness or Jewish identity fits into one of those protected characteristics. Obviously, the two obvious ones are race and religion, but it has to be shown, right? Because Jewishness doesn't exist. It's not assumed. You have to go through a process of showing how it fits into that model. And so that means that for Israel-related anti-Semitism to appear in law, first of all, you have to show that Jewishness fits into the protected characteristics model. Jewish identity does. And once you've done that, then you have to show that a connection to Israel or an affinity to Israel is part of Jewish identity as a protected characteristic. So there's kind of three-stage model that you first, and that's before you get into any kind of decision about whether this or that behavior is a form of Israel related anti-Semitism. So one, you have to show that Jewishness fits into a protected characteristics model. Two, you have to show that there's some kind of connection between Israel or Zionism and that identity as a protected characteristic. And then you can get to the definitional debate, which is this or that form of speech or behavior anti-Semitic? If you can't do those three steps, then there's no such thing as Israel-related hate crime, discrimination, harassment, or victimization. It doesn't exist in law at all. Another thing so I think there are two. So when I was looking at this, the way that anti-discrimination law works and this kind of protected characteristics model, I think there are two competing logics at work, and they kind of contradict each other. And I think they make it very difficult, actually, for UK law and potentially European law to really pick up on Israel-related anti-Semitism. So the first logic, I think, is kind of inherent in the structure of anti-discrimination law. And anti-discrimination law is a grounds-based law, as I said, and the idea is that it's trying to create equal treatment for individuals as individuals, right? So it's not like what's it called? Affirmative action in the US, right? Affirmative action law will, here's this particular group who have suffered discrimination or prejudice or whatever in the past. We're going to remedy that through this kind of positive campaign of action or whatever. That isn't what anti-discrimination law is trying to do. What anti-discrimination law is trying to do is to try and stop the characteristics that it identifies to stop those characteristics kind of affecting the way that an individual is treated in the public sphere or at work or in civil society. So it wants to identify those characteristics, race, religion, sex, whatever, in order to kind of push them out of the public sphere. So in the public sphere, every individual is treated as an individual, and they're not treated differently because of their race or religion or whatever. So it's different from affirmative action. So what it's trying to do is produce, to use a kind of political philosophical term, a kind of abstract or unencumbered political subject who has no real characteristics. The characteristics don't affect the way that it's treated, that this individual is treated in any way. And I think within that structure, one of the things that means is that because of this separation of the public sphere from the characteristics, so the characteristics are kind of pushed into the private space, the private sphere, so they don't impact on the public treatment. That means this kind of separation of the political sphere from the protected characteristics, and they're treated as two completely separate zones, if you like. And I think that has an important impact on the way that the relationship between Jewish people and Israel, and the way that Israel-related anti-Semitism is understood by discrimination law. So I think we've got this two kind of split, dichotomous kind of relationship between politics and protected characteristics. And I think the law forces people generally to pick one side or the other in terms of where the affinity to Israel sits. So on the one hand, you have a Jewish affinity to Israel sits in the political side, which is the kind of public sphere. And that means that that's kind of assuming that for a Jewish person, their affinity to Israel is basically very similar to which political party you might want to vote for, right? It's a choice that's made by an abstract, unencumbered subject. Someone might choose to have an affinity to Israel. Someone might choose not to have one. It's got nothing to do with their kind of Jewish identity, which is a protected characteristic, which is in the private sphere. So basically, that's when you get the argument that says, Zionism is not the same as Judaism. Anti-Zionism is not the same as anti-Semitism. What that is saying is that a commitment to Zionism is a political decision which has nothing to do with Jewish identity. And the proof is that you have some Jewish people who don't have any connection with Israel as part of their Jewish identity. Right? That's the political side of the dichotomy. The other side is the protected characteristic side, which says, and I call this a kind of ontological argument, which says actually Jewish identity is almost formed by this connection to Israel and this connection to the land of Israel and connection to Zionism, and that Jews as a group, their identity is completely tied up with this kind of historical connection to the land of Israel, and you can't separate the two. And it's not political in that kind of abstract understanding of, I vote for Labour or Conservative or whatever. It's part and parcel of what it is to be Jewish, and you can't really understand Jewish identity at all without understanding that connection to the land of Israel. So that's the two kind of dominant choices that I think are kind of set up, if you like, by the structure of anti-discrimination law itself. I think, weirdly, as much as they completely disagree with one another, they're actually quite similar in many ways. I think both of them kind of assume that Jewish identity is fixed and unchanging and kind of essentialized. But they just they disagree. They agree on that, and they just disagree where kind of Israel sits in terms of that fixed and unchanging identity. So on the one hand, affinity to Israel is a political choice made by an abstract subject. It's nothing to do with that fixed and unchanging, essentialized Jewish identity. That's the political side. On the other side, they also say that yes, Jewish identity is fixed and unchanging, but their connection to the land of Israel is inherent to that fixed and unchanging identity. So I think they basically end up agreeing that Jewish identity is impervious to politics and historical development, right? They're completely on upper sides of the argument, but they agree on this, that Jewish identity is fixed and essentialized. So I think that I don't think that argument's very that whole debate is very healthy, but I think the structure of anti-discrimination law kind of encourages that to be the terrain of the debate. But I think there's also another kind of logic within anti-discrimination law, certainly in the UK, which I think perhaps offers more promise for a more kind of flexible way of thinking about these questions. And that kind of lies in the way that Jewish identity ended up becoming understood as a protected characteristic in discrimination law in the UK. So when the protected characteristics model was first set up in the UK, it was in the 1960s, and that was the kind of first legislation against racial discrimination. So initially, race was the only protected characteristic. This was like 1965, and then there was another one in 1968 and 1976. And it was after kind of post-war, you had migrants coming from like former British colonies and stuff. And so they decided to do some kind of anti-discrimination legislation. But at that point, it was just based on race. And they defined race or racial group as a group of persons defined by reference to colour, race, nationality, or ethnic or national origins. Now, during the debate about this kind of race relations legislation, the figure of the Jew was used a lot by both sides of the argument. People who were pro-race relations said, look what happened to the Jews in Germany. We need race relations legislation. The people who were opposed to race relations legislation said, well, hang on, if we ban racial discrimination, that means that a Jewish person in the UK might be forced to employ a German cleaner. Right, that was the kind of argument they had, and there's all sorts of problems with that. But the figure of the Jew was fundamental to this debate. But it was actually unclear whether Jews were actually covered by this definition of a group of persons defined by reference to colour, race. It was never actually clarified within the legislation whether Jews should be understood as a racial group and therefore have the protection by the Race Relations Act. So it was basically left to case law for that decision to be made. And the big case that kind of ended up saying that Jews were protected was in 1983, Mandela versus Darrell Lea, which basically had nothing to do with Jews. In fact, it was to do with Sikhs. But in the course of that case, they decided that Jews were, in fact, an ethnic group. Now, what's interesting about this case is the way that they defined ethnic group generally. And Lord Fraser, in the judgment, his very famous judgment, he set out a load of characteristics that define an ethnic group, and the two essential ones, he said, were a long shared history of which the group is conscious as distinguishing it from other groups and the memory of which it keeps it alive, and also a cultural tradition of its own, including family, social customs, sometimes religion. Now, what's interesting about those definitions of ethnicity is they're historical definitions. It's about historical narrative. It's about long shared history. It's about cultural tradition. It's not this kind of fixed, essentialized idea of ethnicity, which you find in the kind of other logic, the structural logic. And this judgment was actually based on a previous judgment in New Zealand, King Ansell versus Police, 1979, where again ethnicity was defined in this as a kind of historically determined social identity. And I think there's something very promising about that kind of language when you're thinking about ethnicity in general and Jewish ethnicity, and I think it opens up a different way of thinking about the relationship between Jewish people and Israel. So then, okay, what does the relationship between Jewish people and Israel look like if we think of it as a historically determined social identity? And I think thinking of it in these historical terms distinguishes this position from both the political position, which is that, having an affinity to Israel is like voting for Labour or voting for Conservative, and the ontological position, which is that Jewish identity is fundamentally tied up and always has been and always will be with Israel, the land of Israel, and Zionism, and et cetera, et cetera. I think looking at it historically shows that the separation of politics and identity, which is kind of assumed and kind of formalized in the structure of anti-discrimination law, is itself a historical product. It is itself the result of a historical process. And I actually think if you trace the history of that separation of politics and identity, that's by doing that, that's where you can see the actual kind of relation between Jewish identity and Israel and Zionism in a much more interesting and fundamental way than either the political or ontological arguments. Because, for example, I think the ontological position, which says that Jewish identity is always tied up with Israel and always has been, and this idea of return to Israel and all this kind of stuff, it can't explain why Zionism only emerges in the 19th century. If it's always been this kind of desire to return, why is it only in the 19th century that it emerges as a fully formed kind of movement? Why does it take the form it does, which is as a political movement, a national movement, and a secular movement rather than a religious one? Can it just be explained by persecution? I mean, Jews have been persecuted across time. Why at that particular moment was that form of persecution the one that led to some people thinking, let's move to the Middle East? I mean, if you wanted to escape persecution, going to the Middle East was probably not the most straightforward place to go, right? That's why lots of people went to America, and So I don't think the ontological argument really explains why Zionism emerges at that point. So then I probably don't have enough time to go into this properly, but then in the paper, I kind of look at some of the kind of theories of Zionism that are put forward by like Shlomo Avineri and Arthur Herzberg, who basically say that post-emancipation, as the former kind of existence of Jewish identity as a kind of communal or corporate identity in pre-emancipation Europe and Eastern Europe, as that kind of disappears and you have like that's replaced by abstract equality of individuals, the old ground of Jewish identity kind of collapses, and Jews are faced with a problem of how to retain their Jewish identity in the face of the kind of abstract equality of modernity. There are a number of possible responses. One is assimilation, abandonment of Jewish identity altogether. Another is the privatization of Jewish identity as a personal faith, which is kind of that was the impetus behind kind of Reform Judaism, I guess. So you keep Judaism as a kind of private faith in the way that you might think of like Christianity, I guess, and that's some of the debates that you get with Marx when he's writing on the Jewish question and stuff. That's that kind of idea of Judaism as a personal faith. But the problem is, what about those aspects of Jewish identity which don't neatly fit into the private sphere, such as eating kosher food, religious holidays, keeping the Sabbath, maybe having a Jewish education? That doesn't really fit neatly into the kind of just keeping as a personal faith. And then you have competing pressures, which is kind of the rise of romantic nationalisms as a response to kind of the abstract equality of modernity, questions of ethnicity. So on the one hand, Jews find themselves under suspicion in France, Germany as being somehow not kind of ethnically belonging to this kind of new romanticized notion of French or German or whatever nationality. On the other hand, you have Jewish people kind of being more interested in perhaps tracing their own genealogies. So all of these are emerging as a response to the kind of rise of abstract equality and modernity in the 19th century. And the notion of establishing a Jewish polity in the Middle East is a way essentially in which some people thought that these fragmented elements of Jewish identity could be reconstituted under the conditions of modernity in the Middle East through a kind of the establishment of a Jewish state. And that's why it happens at this point. Zionism promises to allow the full expression of Jewish identity without hindrance or fear. It offers the chance of the representation of Jews as an international level. And then with the establishment of the State of Israel, that marks a kind of fundamental change in the status and self-perception of Jews everywhere, even if they don't live in Israel, because it's a trend. It's like a world historical shift, is what I try and argue, from a historical stateless diaspora condition to a historical state-linked diaspora. But my point really is that it's not that Zionism I'm not making a normative argument saying that Zionism is the only road that Jewish identity could have gone to in terms of as a response to the kind of fragmentations of modernity. There were many other roads. I'm not saying it was the right one or that it actually achieved what it promised, what it wanted to achieve, but I'm saying you can't understand Zionism unless you understand it as a response to what had happened to Jewish identity previously. There's a kind of inherent connection between Jewish identity, the kind of fragmentation of Jewish identity and modernity, and Zionism as a response. It's no good thing. You can't understand it unless you think of it through the historical development of modern Jewish identity itself. It's a road built out of the component parts of a fragmenting Jewish identity. And I think both the political position, which treats it purely in terms of abstract terms, and the ontological position, which treats it purely in this kind of essentialized ethnic terms, neither side is able to kind of understand the actual historically determined conditions through which Zionism was produced as a response. So I think that this kind of tradition or logic within anti-discrimination law, this historically determined social identity, offers much more better resources for kind of coming to understand the connection between Jewish individuals and Israel, and by extension, and Israel-related anti-Semitism, than the kind of fixity, the essentialized abstraction of protected characteristics model at a kind of structural level. Thank you.
I'd like to thank all of you and open the floor to questions. So it's Jonathan first.
Matthew, as I understand, you're grappling with the idea of how one squeezes affinity with Israel into discrimination law. Isn't there an easy way of cutting through this by simply saying Zionism is a belief that will fulfill the Granger characteristics, and one doesn't need to get so hung up on whether it's part of a Jew's racial or religious identity, which would also be protected, but Zionism, certain sorts of Zionism, there may be lunatic fringes which might not be worthy of respect in a democratic society, but most forms of Zionism will fall within the notion of a belief. And as we know from Miller, if anti-Zionism can, in certain circumstances, be a protected characteristic, why not Zionism?
The lady.
Yes, just a quick gloss on what you've just said. Of course, you're aware that David Miller, in his employment law case, I think it was accepted that anti-Zionism is a belief and a protected characteristic. This is very recently. But the question is, yes, I agree, it's not a normative argument, and I think that sounds like the correct position. But where does this leave you evidentially coming to court? And I have in mind Ronnie Fraser against the Union, the case. And as I sat there listening after witness, there were many, many witnesses, and how the lawyer for the Union asked each and every one of them, and they all conceded, so there are a range of views, do you agree? And each and every one of them said, yes, there are a range of views on this topic of the Israel-Jewish relationship as being part of the identity. And I think that's pretty much what sunk them. There were other factors as well. But
Sorry. All right, so it's just those two questions to be. Do you want to? All right, then, to respond. Yeah, do you need that? Yeah.
Okay. Yeah, thank you. Yeah, you got Zionist protected belief. This is the thing I'm working on at the moment, because I'm wondering what the relationship is between these different ways of thinking about it. Now, I think Zionism would definitely be a protected belief without shadow of doubt. If anti-Zionism, the judgments of the Miller judgment, and what's the other one, Forstater, which is the transgender thing, the threshold for protected belief is incredibly low. And this actually, there's a question I wanted to ask you about. The fact European law seems to have, it protects huge amounts of speech, apart from Article 17 of the ECHR or whatever. Protects everything apart from outright Nazism and totalitarianism. And so I think it's an interesting question. So I think Zionism would definitely be a protected belief. Now, but the problem is, if anti-Zionism is also a protected belief, what happens? Because the Miller case is an incredible one, which I'm trying to work on it, and it's so confusing because on the one hand he says, I'm an academic, my work is all based on research, academic freedom. On the other hand, in order to pass the Granger criteria, he says, actually, my views on Zionism aren't based on information, it's not a viewpoint or an opinion, it's a belief, i.e. it's akin to a faith thing. That's basically what he argues. Well, if you've got a faith-based view on that Zionism is evil, which is what he basically argues, that's anti-Semitic, right? Like, Yeah. It's quite,
Academic freedom. That's why the principle of academic freedom is inconsistent with the Granger criteria, because a true academic doesn't have a firmly held belief. They argue back and forth. Matt and I were talking about this yesterday. So there's a tension between.
Definitely.
Anyway, sorry.
Definitely. So the problem. But if then Zionism is protected and anti-Zionism is protected, so if the view that Zionism is was it colonial, imperialistic, racist, and Miller says shouldn't have a place in any. If that's protected, and then it's also protected that Zionist, at the very, let's say a minimal Zionist belief, which is that that Jews have a right to self-determination in the Middle East and a Jewish state is legitimate or whatever, just an absolute minimum thing. Well, they clash. They come into they complete contradiction. I don't know. It doesn't really get you anywhere. Like, so then I'm not sure then how how that helps you in.
Well, first, in terms of protecting Zionists, it's a philosophical belief. I think we can agree that. Then an anti-Zionist, on the particular facts of Miller, it having been conceded that he wasn't anti-Semitic, then yes, in those rare circumstances, or perhaps not so rare, but whatever, in those circumstances, then yes, that can be a protected belief. Bundists were anti-Zionist, but nobody would say they were anti-Semitic. So there can be very proper anti-Zionist beliefs that aren't anti-Semitic, but where that belief, based on tropes, collapses into anti-Semitism, as it very often does, Dave Hirsch has shown, then it's not going to be protected because it won't be worthy of respect in a democratic
but then
society.
just to respond to that, then we get back to this question again, because then it's like, okay, where's the line? Does the law recognise anti-Semitism?
Well,
do we have to go back to Jewish identity?
It's all the problem is it's the common law. It's all going to be fact specific on a case by case basis, and that's the way the courts will, I think, end up dealing with it.
Yeah, but they have to do it via the route that I'm talking about because they don't have a concept of anti-Semitism. Anyway, this is the fascinating. I'll talk to you about afterwards.
Just make a point though, Jonathan. You talked about the protected characteristic thing, the protected philosophical belief is about discrimination, whereas the related to test, if we're going to say that I'm harassed by anti-Israel conduct, that requires the conduct to be related to my Jewish identity, right? So it's a different offence. Harassment so I think Matt's talking about harassment in the context of anti-Zionist or anti-Semitic, anti-Israel activity.
It depends on which set of laws you're looking at.
It depends on which law you're looking at. So if you the way harassment is defined, it's unwanted character. It's an unwanted conduct, unwanted behaviour, unwanted conduct related to protected characteristic, but it has to be related to.
Yeah,
I'm not sure. So it does depend on the law.
Yeah,
it's the specific law.
Unlike the continent, everything's rather bitty here.
Different from London.
And just to quickly respond to the Ronnie Fraser one, well, a lot of the paper initially I based it on that case because I felt that the arguments were being forced into either this political abstract connection, which is the way that the judge ruled on the case in the end, or it was the kind of ontological one. And if you couldn't prove the ontological one, that meant that the case was dead. Now, I think Anthony Julius in that case was trying to argue for this complex, historically based thing, and it didn't work. But then, as Leslie's shown in her work, then you have things like to assume Jewish identity without the arguing for it. I actually ended up agreeing with some of the criticisms of that report that came from what are they called, Jewish Voice for Labour, who basically argued that whole report kind of didn't actually engage with the law because it was starting from the point of anti-Semitism. It wasn't looking at Jewish identity. It didn't argue didn't state the argument of how Jewish identity relates to Israel. It didn't do it all, and I think that's quite weak as well. Anyway, thank you.
Thank you. The gentleman there wanted to ask a question.
So, no, that was fascinating, and I really loved the way you've conceptualized it. I guess my question goes to then, is this essentially placing most of the determining factor over what constitutes actual anti-Semitic conduct in the erasure of Jewish identity? Because I think, like, I'm Australian. I've said this probably 50 times now in these different panels, but we've got a very similar legislative system to the UK, and we're a little bit behind in terms of case law. So we are informed by the experience here probably quite a lot. And I think it's interesting because being able to divide the line between what is legitimate criticism of the Zionist project versus anti-Semitism is obviously very difficult at case law. And I sit on the board of a strategic litigator in Australia now, and we're picking and choosing cases we want to go after to develop the area. But one of the essential sort of thoughts for me then goes back to, which I think this solves, is how do you actually capture what it is about a lot of the speech that is so anti-Semitic quintessentially, as opposed to just being statements? And I think what's beautiful about it, and so this ends up being a comment more than a question, is more just that when you're looking at things like, the charges of Nazism or whatever, the essential historical contingency of those claims is what makes it especially egregious to us, as opposed to comparing it to Pol Pot or another regime. Mm-hmm. And I think that that's a really good thing that your approach captures, and that I haven't actually really thought of before. So it's fantastic.
Cool, thank you. I mean, the other thing, which might not be popular in this room really, the other thing I was trying to do is trying to get hold of the fact that it is true that there are, a fair number of Jewish people who do not have an affinity to Israel, right? And that often define their Jewish identity against Israel. And maybe that's growing in the number, I don't know. And I think it's also wrong for someone like me to come along and say, if you don't have an affinity to Israel, you don't have a real Jewish identity, right? And which is the way that Trump thinks about it, right? I think that is an awful way of doing it. And I think, but then the law really struggles with that. And I'm trying to make comparisons or think about other groups or other issues where you have the protected group who have a diversity of views, and yet you can't say that the particular topic that they're talking about is somehow completely separate from the identity. Like it's very, so it's trying to think of it historically, I think opens it up because it allows for debate and diversity within the protected group, but it also, I think, then weakens, like you were saying, the ability in court to make the argument because it's kind of, fuzzy. It's fuzzy.
I know that you've looked at the comparison in the case law with Sikh communities. Have you looked at Indigenous communities? Because I think that's there's some of the other stuff in other areas of anti-Semitism research now looking at Jews as an Indigenous people. And that connection to the land is, very much like an Indigenous Australian or Indigenous Maori from New Zealand. And that kind of relationship is very fundamental to general Jewish culture. And even if you're not aligned in the way that maybe the predominant culture is, I think that sort of captures that relationship much better. And so that's something to think about. And I know we're talking about, no one's done anything yet, and it's still a very nascent area of research and activism, but I think it's definitely a promising path.
Question over here.
Yeah, I hope it's okay, but if I can take the discussion to a quite different area, which is even more complicated and much more difficult to connect to legal terms. I'm coming from the area, the media coverage, monitoring, etc. And in generally speaking, the most of the left-leaning media applies a completely different framework for covering hostilities, Israeli-related hostilities, than any other place. Very quickly, the main story in the Israeli case is the collateral damage. It is inflated, in the most sensational fashion, etc. Now, it's, as I said, it's quite complicated, but I would like to put it into a certain point. I'm analyzing the Guardian's printed edition for the past 25 years. And one bold example is the Guardian attitude to publishing images of dead bodies in general and children in particular. In general, Guardian applies strict ban, much more than any other outlet. For example, even in the case of Bucha, where virtually every paper published on its front page, the image of the main street there full with bodies, the Guardian published the same photo without any bodies. And the opposite applies to Israel. The publication of corpses and most notably children is the norm. They have published hundreds of such images during the past 25 years, including many extremely gruesome, etc. Now, in a more civilized universe, it should have been straightforward to sue them for discrimination, whatever, but obviously we are not going to get such universe shortly. My point is that I think it can be possible to take it into the area of libel, collective libel, which is obviously very complicated in relation to media and free speech, etc. But at the same time, it's absolutely unacceptable that this kind of discrimination is can't be accountable in any way. So I think it could have been possible to promote amending the current libel law with a clause a bit similar to the idea of the IRA definition, but not specifically to Israel. I would like to consider the situation in which the Daily Mail, for example, would have applied similar attitude, similar pattern in relation to Pakistani's car accidents, publishing them on the front pages with lurid images, etc., or the Bild applying the same to Turks in Germany. Obviously, it can't be acceptable. So my question is, first, what is the current situation in such a case? Is there anything legal that can be done in that regard? And the second, what is your opinion about trying to amend it and trying to promote some kind of way to deal with that? And just to add one sentence, I don't have in mind making it the same like usual libel. What I'm thinking about is not, for example, financial penalties, but corrective measures that are put in law. So what is your opinion on that?
I'm not sure that's what the panel was here to talk about, but I don't know. Do you want to try and answer it? Or I don't know libel law. I don't think is within our remit, making changes to libel law to make newspapers and things accountable. Would anybody here like to address it? No, I don't know. I think we possibly need. Does anybody? Yeah, I think we need to. Yeah, I mean, it's probably a very good question, but I don't think we can answer that. Actually, it's not the topic of the panel. But yeah, of course, it all broadly relates to misrepresenting and demonizing. All right, the gentleman there.
All right, I have a question for Christoph, because you pointed out that it's important in German law that the citizens know what is punishable and what is not punishable, and you also proposed that the legislator should probably legislate the IRA definition or some definition of Israel-related anti-Semitism. And if you're talking about the IRA, which I'm a proponent of, but obviously it doesn't include all sorts of anti-Semitism, all kinds of anti-Semitism. Would this then mean, if the legislator chose to put the IRA into law, that other kinds of anti-Semitism that are not explicitly mentioned would then the judicial system would not be able to treat them as anti-Semitic, because the legislator has said this is what we understand anti-Semitism to be, and other examples under other forms of anti-Semitism are not mentioned in that, and so the courts would not be able to prohibit that as anti-Semitic. Would that be an issue if we put that into law in that way?
There will always be cases you cannot cover with any legislation. You won't be able to do that, especially in a civil law system like it is in Germany, where we don't rely that much on cases and on court decisions. You always have an abstract definition and have to work with that definition. And because such definitions want to cover as many areas of life as possible, they have to be broad to some extent. But it's the thin line between the definition being able to catch enough and the definition being so broad that you cannot really do anything with it. That can be limited if there is a constant there is a constant stance in jurisdiction that, for example, the crime of insulting a person, which our legal system has, Beleidigung, it just says whoever insults a person will be punished with this and that. Completely uncertain what that means, but it was brought to the Constitutional Court, to the Federal Constitutional Court, and they ruled, okay, there's enough case law to know what that actually means. So it really depends on the definition and the history of that definition, and that exactly was the problem with what I told about case law of Israel-related anti-Semitism in Germany. There is no current stance. So unless the judiciary finds a common definition, the legislator has to act in order to make it more clear. But there will always be cases you cannot cover, and there will also always be a space where the courts cannot punish certain behavior. And I think that's not a weakness of a civil law system. I think it's a strength, because that makes room for judges to make actual decisions. Of course, you could try to lay down every possible scenario in law, but then just one section in the criminal code would have like 400 pages. So that's not possible. You will never have a criminal offense that covers everything you might want to cover.
I guess the IRA can be a starting point also for judges, for prosecutors to like see if something might be anti-Semitic, but it doesn't stop there. So what we argue in the research project I'm part of, which analyzes legal actors and their application of anti-Semitism definitions, we argue for more education towards actors in the legal system, so that they can see in a workshop, okay, there is the history of anti-Semitism, these are codes and ciphers that are being used in anti-Semitic discourses, which you can't be learning by just looking at the IRA definition once. And if you have read it 20 times, it's not getting better. But you need constant education on it, and that's a good starting point, I guess, additional to the IRA definition.
Yeah, can I just ask something that you've all three of you have spoken about problems with the German legal system and the police and so on in recognizing anti-Semitism. So do you think it is just, and dealing with it appropriately, do you think it is just lack of education or lack of training? I mean, can it be remedied by a well thought through training program, or is there some other possible factor that's causing this problem?
Shall I answer and you can add to it if you want to? Yeah. Okay. I don't think it's all there is to it. Like Matthew said, there is certain differences between like our everyday language, our political language, and the language of the legal system, and will always be something lost in translation. So, for example, I got you the example where the anti-Semitic motive just wasn't touched at all in the court proceedings because it was easier. And in some cases, it's just easier to crystal clear prove that there was an assault, but it's not that as easy to prove that it was anti-Semitic. So, and if you will try as a judge to prove it, that someone was motivated by anti-Semitism, then this can be appealed. And no judge wants to be appealed. And if it's easier to just prove it as the act of assault, and it's not that clear if it's anti-Semitism, it's a problem in the legal system. So you can't always go there, but maybe you can add to it.
To the judiciary, I can answer to the police. What we would argue is, of course, police officers, they need better training in the IRA especially, and they need better sensitivity towards those affected by anti-Semitism, definitely. But their statistics can never really kind of grasp the whole problem, really, and we would argue strongly for data sharing agreements, which are in effect in the UK, as I know it. In Germany, we don't get good data from the police, and when we get it, we see they are lacking, in part because they don't understand anti-Semitic crimes that they have to deal with.
So is yes the equivalent of our community security?
Yes.
Minus
the security part. We deal with the police, yeah, and we get data, but mostly we don't. Yeah.
Yeah, I would like to add something. We have to make a difference between the executive branch of government, meaning police, and in Germany, public prosecutors. They're not part of the judiciary, and judges, because you can force prosecutors or police officers to take courses, to be educated on the topic. But if you go to a judge and say, you have to take a course, they'll say, no, I'm independent. I don't have to do anything. I have to do my work. And even my work, if I say I don't want to work on Mondays, then that's the case, and I'll schedule everything on Tuesdays. So you wouldn't be able to have compulsory education for judges. So that's a difference. With police and prosecutors, it's easier.
I'd just ask you about your thing about the river to the sea thing, and so there's 3 different decisions, and are those courts all around the same level? Or is there like a higher authority out of any of those? That's one question. And second one, I'm just really interested in this European law question, because it seems to me if they did, because I think what you're arguing is that any kind of legal clarity would be better than this kind of mishmash, and no one really knows what's going on at the moment, right? But I think you would really struggle in if someone took it to the European court to say a kind of blanket ban on, from the river to the sea, given that I do think there is a huge, like any statement, there's a variety of contexts in which it can be said, right? And if someone says that, on October the 8th or whatever, I think that's fundamentally different to if someone says it today, for example. I do think there's a difference there. And having a blanket ban, I just don't see how that would stand up in European law at all. It would be, it would really struggle. So I just wonder, and also I don't know, even in the education question, even if you had IRA, I mean, it's hilarious that they've only adopted the core definition of IRA, which is like, all due respect, absolutely awful, like no examples. You'd be better off adopting the JDA core definition. That's a better core definition. Whatever you might think about the actual debate, the actual core definition, I think, is better than the IRA core. Yeah, but even if you adopted IRA, I still don't think that would fix and even the examples. I still don't think and had education or whatever. I could give you 30 experts in anti-Semitism who'd all disagree about whether this particular phrase in this particular context was anti-Semitic. So I don't know whether it would even work, depressingly. But anyway, it's to everybody. Well, one part was to you, and then the other part was to you.
Okay, let's have a quick response, and then we can. Yeah.
Oh, okay. Yeah. To your first question, what level are they? Two of them are criminal courts. One is an administrative court. That was because it was about a public protest, and that protest was to be forbidden, and that was discussed in that trial. It was a higher administrative court, so it's one level under the highest administrative court we have in Germany. So that was the Munich decision. That was the more differentiated approach, where they said, yeah, context is key. Regional Court Mannheim and Regional Court Berlin are second instance courts. Yeah. The European component, I think you mean if someone went to the European Court of Human Rights, or for example. I find it hard to say. It depends on how political they want to be. And in my experience in research, the European Court of Human Rights wants to stay as distant to politics as it can. And they constantly do that. That's, for example, the thing with abortion as well. Always, if it's a political matter, then sometimes they don't even decide it, and when they decide, they basically say, okay, that's a member state thing. And I think it could be the case with that as well, because it's too politically controversial.